Therefore, I do grant defense motion to strike in whole on all counts, all 8 counts of felony child abuse and endangerment under indictment CR, indictment number.
On Thursday morning, May 21st, we saw the conclusion of the highly anticipated criminal trial against Ebony Parker. She was the former assistant principal at Richneck Elementary School the day that first grade teacher Abby Zwerner was shot by her 6-year-old student. Parker was charged with 8 counts of felony child neglect, and on the 4th day of the trial, which was more than 3 years since the gun was fired in Zwerner's classroom, the judge decided to dismiss the charges against her. Welcome to True Crime 757. I'm Jon Sham. I'm joined today with Eric Korslund, our legal analyst, and Brendan Ponton, our reporter who covers Newport News, and he was in the courtroom all last week for this case. So first I wanted to get into, Brendan, what was the mood like in the courtroom when the judge decided to strike to strike this case down, basically saying that effectively dismissing the charges?
Well, as Eric can weigh in a second, I think there's a feeling of surprise that the judge was going to be dismissing the case. When she first started out in issuing her ruling, she kind of chastised the defense a little bit, saying, I thought you were going to provide more of an argument about why I should dismiss this case. And then she went on herself to say the conduct in this was not a crime. And basically, if the General Assembly or people think it's a crime, they need to change Virginia law. So at first, I think people were surprised, but then Dr. Parker started audibly sobbing. And then, we as news media people were kind of like, oh, we really got to go make sure we're, covering this big development in the story. But I know Dr. Parker wound up hugging several of her family members and attorneys. So it went from being kind of a surprised mood to triumphant for the defense side.
So this is kind of unusual in a felony criminal case. Have you seen this before?
It is rare, but yeah, we see it all the time. It's called a motion to strike, and it is rare because the jury is the trier of fact. They're the ones that determine factually what happened. And so in this particular case, the judge is intervening and saying that the jury shouldn't even get this case to decide on it. So a motion to strike means that the judge is to view the evidence in a light most favorable to the Commonwealth, to grant them all reasonable inferences from the evidence. And if a prima facie case isn't met, then she strikes the evidence. So it is rare, and I don't think the defense was expecting it. A lot of times as defense attorneys, we make the motion to strike, but we don't put too much weight into it, too much zeal, because we expect the judge to overrule that. So I think it was surprising to everybody. And in fact, what the judge said is that there were multiple legal theories pushed by the Commonwealth, but none of them met the statute, and none of them defined a crime that was committed. So she basically said very simply that there wasn't a crime that was committed here. It doesn't mean that Dr. Parker didn't do anything wrong or she should have acted differently, but to say that there was a crime committed here, it just wasn't. And in fact, she went on to say that if the legislature makes something like this a crime, then that's a different story. But right now, what's before her is not a crime.
So, and we did talk about this in the preview podcast where we discussed, the legal burden for taking away somebody's freedom, right? Yeah. And you had said in that previous episode, that you kind of agreed with the outcome of the civil case, but you really thought it was going to be difficult to convince a jury of of Dr. Parker's peers that she was criminally negligent to the point where that her liberty would be taken away. And it turned out that, that the judge agreed, but even before kind of giving it over to the hands of the jury.
Your world changed in seconds, not by choice. But now you get to choose who fights for you. At Korslund Law, we don't just handle cases like the other firms. We go to war to get our clients paid for their injuries. Personal injury, real people, real stakes. Let us carry the weight. Free consultation, fierce representation. Korslund Law, because this fight is personal.
And that's why I tell you that this case is not about Miss Zwerner. This case is about the 19 children whose lives were endangered in that moment, but in the moments before as well. Those children were, some of them, between the gun and Miss Zwerner. Some of them a slight movement of the gun could have hit a child instead of Miss Werner. They're right there. Some standing shoulder to shoulder with the shooter. All of them, you'll learn, watched as their teacher clutched her chest and bled before these children, screaming in horror, ran across the hallway to another teacher's classroom. And Miss Werner ran to the office and collapsed on the floor. Where, at that point, was Dr. Parker? She had locked herself down in her office.
The Commonwealth has to prove beyond a reasonable doubt that she's guilty of the allegations that they are presenting. The Commonwealth has to prove that Dr. Parker was a guardian or other person responsible for the care of the alleged victims. Before Dr. Parker, there was the teacher, Ms. Warner. And the Commonwealth has to prove that Dr. Parker's willful act or omission in the care of the children was so gross, wanton, and culpable as to show a reckless disregard for human life. Who was the person that saw these events from beginning to end? That was the teacher, Ms. Werner.
One of the things that I noticed, because we were watching the case, back here at the station, is that the defense took a very minimalist approach, right? They didn't have a very long, the prosecutor's opening statement was very long, like 15 minutes, and the defense opening statement was just a few minutes long. The defense ultimately didn't bring any witnesses. It was the prosecution's case, and so there wasn't like a closing statement, from either side. What does that tell you about the defense's case kind of going into that?
I think in some cases, it says a lot for the defense not to put on any evidence. The jury's clearly instructed that in a criminal case, the Commonwealth Attorney's Office, they have the burden to put on evidence. And they have the highest legal burden of persuasion there is, of proof beyond a reasonable doubt. So sometimes it sends a message to the trier of fact of, we don't need to explain anything. We don't need to put on any evidence. We're simply going to sit here, rely on our presumption of innocence, and have them prove their case. And I've said it many a times to juries in closing argument. I'm just looking at them and saying, prove it. And it's their burden to prove it. And again, they didn't. I don't put too much weight that he didn't call Dr. Parker to testify or they didn't put on any evidence. I think it was probably a good strategy move. It's difficult to show that a crime was committed. And this is a case, I think, that's unprecedented. I don't think we've ever seen anything like it in the country where a school administrator is put on criminal trial for her inaction of doing something. One thing the defense did do that I thought was pretty clever was they pointed out to the judge there were other school officials that knew or had the same warning signs as Dr. Parker. They didn't do anything, so why aren't they indicted and why aren't they charged? Why does this solely rest on Dr. Parker? And I thought that was a good point. If we're going to go down the slippery slope of charging people who don't do anything, where does that end?
Personally did not call the police, is that correct?
Correct.
You personally didn't ask anyone else to remove JT from the classroom, is that correct?
Correct.
You would admit that the person that has the first responsibility to protect the students in the classroom is you as the teacher, is that correct?
Correct.
And you would admit that you did not take any steps to protect the students from JT, in your words, potentially being armed with a firearm, is that correct?
I would not admit that.
Even Abby Zwerner herself had some warning signs that she expressed to Dr. Parker. I'm not trying to put her on trial by any means, but just hypothetically, why couldn't she have done something? And I speculate that the judge may have been looking at it through those
Right, and
eyes
the
too.
defense
Yeah.
did ask, those questions of Zwerner when they had her on the stand, and there were times where she, Brendan, you were there, she kind of had to admit, yes, there probably were more things that I could have done.
Yeah.
Well, a big question the defense was asking to that
Yeah.
point was, as a teacher, could you have put the student JT into a different classroom if you were that worried about the safety of him? And she said, in hindsight, yes. And so I think, as somebody observing the case, it was kind of a powerful moment that, is this beyond a reasonable doubt all Dr. Parker's fault, or is there reasonably other people who could have intervened? And I think that was actually something that was going well for them, perhaps. There was a juror who made kind of like an offhanded comment to us after the case was over, saying why, in her opinion, the other people could have been charged and not Dr. Parker. So that did seem to be something that maybe people were buying.
Yeah.
What happened on January 6th? Second, why did it happen? And third, what can be done to ensure that it doesn't happen again?
Yeah.
So one of the things that Brendan and I kind of talked about, before the podcast is that this case was brought by the Newport News prosecutor, the former Newport News, prosecutor, Howard Gwynn, a few years ago after the shooting happened, who was voted out of office last year. And so can you kind of explain a little bit of the history? And then I want to ask you, Eric, of just kind of what kind of impact that might have on the prosecution's case. Can you give us a little bit of that background?
Howard Gwynn took this case to a grand jury and then had a grand jury review it, and they issued the 8 felony indictments. And then he wound up losing his reelection. And so one of his assistant commonwealth attorney in Newport News wound up going over to Hampton, and they wound up appointing him as a special prosecutor in the case, Josh Jenkins. And so he was the prosecutor who had been working on the case when he worked in Newport News. But then when he moved over to Hampton, he took on the case there.
What kind of impact, kind of a changing of the guard, in a matter of speaking, have on a prosecutor, even though it was the same prosecutor who had been working on it, but, kind of at the top, obviously, that could have some kind of impact?
In my opinion, I don't think it has any impact, because at the end of the day, it's up to the jury. So if you have the original prosecutor that's presenting the case to them, or maybe a brand new one who's just becoming familiar with it, or even a prosecutor from a different city, they're not going to know. They're not really even going to care. Their concern is the jury instructions and what evidence they have before them. It sounded like to me that there was maybe a little bit of backpedaling when they were given their statements, and that's from the Commonwealth Attorney's Office. And I see this all the time, and they want to say, look, the grand jury indicted them. The grand jury returned a true bill. I don't put too much weight in that. There's a cliche that goes, a grand jury will indict a ham sandwich, and it's true. Grand juries are done in secrecy. It doesn't have to be unanimous. Hearsay is admissible. Defense attorneys aren't allowed there. So a grand jury can be presented with very scant or little evidence, and they're going to come back with a true bill. I say to that, so what? In fact, there's a model jury instruction that says they're not even to consider the fact that the grand jury returned a true indictment. I think this is a classic case of hindsight's 20/20, and that's just not reality when these tragic things happen.
If they are to amount to a crime, then the legislature will need to codify it. Therefore, I do grant defense motion to strike in whole on all counts. All 8 counts of felony child abuse and endangerment under indictment CR, the indictment number 24999-541-01-08. So those matters are dismissed. I want to add, my ruling today is based upon legal principles only. It is inappropriate for me to give my personal thoughts or express sympathy or concern. But it's understanding what happened that day was awful, that was agreed upon by all. The criminal matter before me does not call for me to discuss the Newport News school system or make political observations, and I will not comment on
The thing that I keep going back to is that the judge watched the prosecution put on a case for two full days, and after they wrapped their case, the judge said, I don't think that they're I don't think that there's a crime. The defense said, we're filing a motion to strike this case. And the judge said, I agree.
I think her comments say a lot to me. There's a lot of different rationalizations a judge can give for granting a motion to strike. And in this case, she just flat out said a crime wasn't committed. So I think she's looking at all the evidence, and as a whole, it's just not criminal conduct. And that's the issue I had coming into this. She also made a comment about, I said earlier, there's different legal theories. Where's the child neglect? That she didn't tell somebody to stop JT, that she didn't shut down the school, that she didn't do this. Where exactly is a child neglect? And I think it was unclear to the judge What exactly she did that was child neglect or she didn't do, which was child neglect. She even made a comment of the 8 counts. Is that for the 8 bullets? Is that for 8 kids that could have been injured? Or is it, it was just very unclear to her. And I think there was some wrongdoing, but that's why we have civil suits and that's why we have lawsuits. And just because somebody is civilly liable doesn't mean that they committed a crime.
Right. That's different than the gross wanton
Absolutely.
culpability that's laid out in the
Absolutely.
criminal code.
One of the arguments the judge was making was that the bullets were not fired, and like that might have an impact on how the code is written. I mean, does that matter at all to you?
The bullets not being fired shows a potential of harm. The bullets being fired is a more real harm. So I don't know if that's where she was coming from, but I think it's just speculation, and it requires the court to surmise what may have happened or what may have not happened. And in a criminal case, it's very difficult to get a guilty verdict based on something like that, what could or couldn't have happened. Even if somebody is harmed, and the example that I go to is car accidents. People are killed, severely harmed. Obviously, there's some element of neglect there. Otherwise, it wouldn't have happened. That doesn't mean somebody's criminally responsible for it. I get a lot of cases, and they're very, very sad, where a juvenile inadvertently shoots another individual. They're playing with a gun. And in some of those cases, it's not criminal. I mean, there's been cases where firearms have been mishandled and people have been shot, and the courts have ruled, that that's not child neglect or, some form of criminal neglect. So in this case, I have to agree with the court. It's one thing to hold her civilly liable, make her responsible. I think she does have to wear that accountability, but to make her a felon on something like this, I don't think is appropriate.
Your world changed in seconds, not by choice. But now you get to choose who fights for you. At Korslund Law, we don't just handle cases like the other firms. We go to war to get our clients paid for their injuries. Personal injury, real people, real stakes. Let us carry the weight. Free consultation, fierce representation. Korslund Law, because this fight is personal.
Ms. Zwerner never came to me and said anything about her fearing that the student had a weapon or that she felt unsafe. She didn't say it.
One of the things that was unique about this case compared to the civil case is that we heard from Dr. Parker for the first time. She didn't testify, but a video of her doing an interview with the Newport News, school's HR director, was an extensive interview after the shooting was played in court. How do you think that played into the outcome of the case, Brendan?
I think some of us who had been watching the court all week were a little surprised that the prosecution was entering that, because Dr. Parker is shown crying. She's shown saying she didn't know that the student had a gun, and it made her seem human and you sympathetic perhaps that, and the video is from just a few days after the shooting, so it was very, very fresh for her. So yeah, Eric, I mean, I know you weren't able to probably watch all minutes of the court, but I mean, the fact that they played a video that was kind of sympathetic in a way, I mean, do you have any thoughts on, why that might be a strategy?
Well, I think a lot of prosecutors, they love to play the defendant's statements. And sometimes they can be a little overzealous in doing that because some of the statements can be self-serving. I've had plenty of criminal cases where my client gave a comment to the police and the prosecution chose to play it. Well, I lean over to my client and I say, hey, you don't have to testify. The judge or the jury already heard from you. So I think that probably was a point against the Commonwealth. I don't think that necessarily helped their case. And I think it also highlights that this was a mistake that was unforeseeable. Again, if I was a prosecution, I would not play any self-serving statements of the defendant. I would want the defendant to get up there in that witness stand and allow me to cross-examine them. In fact, in the OJ trial, there's a point where OJ's trying on the glove and he's mouthing, it doesn't fit. He doesn't say it, but he mouths it. And there's been some criticism of the other side. They should have said, hey, he just testified. Now let me cross-examine him. And I'm sure that would have changed the outcome of that case. So I think they made a mistake by playing her statement.
What was it like for you to hear that the judge was tossing out the case? You seemed to get emotional.
You feel vindicated?
So what's next for Dr. Parker? Parents of 3 different children from Richneck testified, and they all said that they were pursuing civil litigation against Dr. Parker in Newport News School Division. So while this, while Parker's time, for her criminal charges, that time is ended, what remains to happen out of this Richneck shooting?
Well, those cases are still playing themselves out, and then the civil case that the $10 million judgment was declared against Dr. Parker, that case is still in the process of being appealed. And so, those processes can take quite a while sometimes.
Absolutely. Right? And I think on the civil side of it, the attorneys for her are probably happy about this outcome because it makes it easier for them to collect the money as opposed to this was a product of some sort of criminal wrongdoing, which a lot of times insurance doesn't cover. So ironically, I think her team of attorneys are probably happy about this outcome.
Zwerner's attorneys are happy about this outcome.
Correct.
Because it does in some ways impact this issue during the appeal. Is that what
Absolutely,
you're saying?
absolutely. I think it shows that this was more of a bigger problem that could have been handled by the school as a whole, as opposed to just blaming one person and making it criminal conduct on their part. So I think they're happy with it. The other parents that are suing Dr. Parker, the school, my concern with those cases are what are their damages? You can't really argue that with Miss Zwerner. I mean, she was shot through the hand and then the chest, the physical, the emotional damage. It's all there, and you could put a price tag on it. But for the other parents that didn't even know about this, and for their students that were probably unimpacted by this, really at the end of the day, I don't know what kind of lawsuit they're going to have.
Right.
Yep.
Right. And I think that, it was brought up a little bit, by the defense when they were asking those questions, just about, well, how was your child actually impacted by this? And
Absolutely.
they did have, they said, hey, they're in therapy. They have trouble sleeping. I think one of them said their kid, wets the bed, more frequently now. Anything else that you think be worth sharing with folks, Brendan, from your time in the courtroom last week?
Well, I'd be interested in Eric's opinion on this. So there was a point in the trial where a juror said he had a question, and the judge allowed the juror to come into the courtroom. None of the other jurors were there. And he said, are we allowed to use information that's being objected to and sustained? And the judge said, have you asked that question to anybody else? And the juror said, yes, I've asked that to the other jurors.
Mm-hmm.
And then the defense made a motion for a mistrial, and the prosecution actually also said, we don't disagree.
Mm-hmm.
And so the judge said, okay, both sides say they want a mistrial. And so she went back for about 15 minutes and came back and said, essentially, just because the fact the juror asked that question to his fellow jurors, it wasn't, a point of, it was a matter of fact. It wasn't like a real contentious part of the case or anything like that. So she allowed the case to go on. But it did seem a little unusual for both sides to ask for a mistrial.
Yes.
And then the judge said, no, we're going to continue on.
It's very strange. Sometimes the prosecution, they may want a mistrial as opposed to getting a guilty verdict, and then it's reversed on appeal and they have to try it again. So that may have been Mr. Jenkins and his approach to joining in for that motion. The defense, clearly they have their agenda for asking for a mistrial. Me personally, I don't like mistrials. It just means you have to do it all over again. And mistrials, in my opinion, tend to help out the prosecution side of it. Now, getting to the question, can we consider stuff that has been objected to and sustained? Well, absolutely not. I think a creative instruction could help out with that. The judge simply instructs the jury, you cannot consider anything that's been stricken or just don't consider any of that evidence. The other problem that you have with that is the jury's not supposed to deliberate in any way until they're given the final instructions and they're sent back to deliberate. And so when this individual is saying, I was talking to the jurors about this and that, it really tests the boundaries of when you should deliberate or not. So I think that may have been the other problem as well.
And I think, is there a strategy on the prosecution? Like you said, sometimes when we've covered cases and we see them go to a retrial, things seem maybe a little bit more organized on the prosecution side and how they're presenting a case. Is there sometimes, a prosecutor sees how a case is going and maybe feels this isn't going the best, and if somebody wants to do a mistrial,
then they got to do it again? Yeah, absolutely. Do-overs are great, and we don't really get them in this business. So especially prosecutors, we do have a double jeopardy, and so they're very, very aware of that. So if things went not quite as expected, I don't know if that's the situation. I mean, they had 16 witnesses. I think there wasn't too much of a factual dispute here. I think it was more, does this rise to the level of criminal neglect? But we all have our own strategies and keep our cards close to our chest. So who knows what he was thinking? Yeah.
Well, I want to thank you both for coming on the podcast today to recap. This obviously was a really, really big trial case that a lot of people have been paying attention to for several years now. So this has been True Crime 757. I'm Jon Sham, and we'll see you next time.